lady. May I just pick your ladyship up on a point you made before we rose?
Please do.
Was that your ladyship said that my client should have disclosed the document?
I did.
My lady, a party discloses a document when they state a document exists. It is then for another party, if they wish to either see that document or even inspect it, to ask for it. So I don't accept, my lady, that my client didn't disclose the document per se. And may I go on to say this, that had my client been asked to produce the document and had the wife taken issue with it and asked questions about it, we could then have addressed it, which we did not have the opportunity to do. So, my lady, can we then move on and deal with the transcripts?
Certainly. We have, as promised,
I'm so grateful. Thank you. So, lady, if we can go, please, to page 225. And this, of course, I remind the court, was before the letter was produced. So we have two, it was separate parts of this cross-examination. One was before the letter was produced to the court, and the other after. And it is perhaps more illuminating to look at the second part of the cross-examination, but focusing for the moment on the first part at page 225. At B, in answer to a question from Sir Jonathan, in respect to the letter, my client said it wasn't intended to be false, my lord. It was trying to explain the structured arrangement which had created the letter. And then back to Mr. Glaser, and the letter and the whole purpose of it was to pretend to the regulators that the bank had more money in it than it did, correct? No, the letter was intended to be used in support of a bid for another bank. Okay, so it was never used because the bid process never proceeded. And then Mr. Glaser, so the letter was created to give a misleading impression to a bank you were bidding for. The letter was used, intended to be used to support the bid process on the basis of liquidity to effectively complete an acquisition. And Mr. Glaser again, but it was a presentation of a false position. No, because the liquidity was within the bank in respect of its retained earnings and as invested. And then Mr. Glaser, but you, the letter didn't say, I've got this account with several million in it, but I can't touch it because it's a blocked account. No, it was, what was relied on was something, the money, it was intended to create an impression when there were ready liquidity, Mr. Glaser, when there wasn't, when in reality the liquidity was tied up in the capital of the bank and would have to have been liquidated over time in order to then inaudible. So Mr. Glaser, so it was created, so it was to create a misleading impression that there was liquidity when there was not. That's your interpretation. That wasn't the intention. It was effectively to demonstrate our ability to proceed to the next level within a bid process, which in itself never actually proceeded. So the thrust of Mr. Glaser's cross-examination was that the letter was designed to give a false and misleading impression.
I'm not, for my part, I say so, I'm not entirely convinced that that is the correct interpretation of Mr. Glaser's questions. It occurs to me, reading that passage alone, that what he may have been doing was trying to tease out what exactly your client was saying. So when he says, so it was to create a misleading impression that there was liquidity when there was not, that wasn't necessarily, you may be right, but it's not necessarily his case, as just reading it. It's trying to elucidate what your client was saying about it.
Well, he didn't suggest to my client that in fact it was true, and I'm going to come on when we actually have the letter to show you what Mr. Glaser did then.
And I do think we have to read what Mr. Glaser did in the context of what the judge had been saying for 2 or 3 pages before that.
Well,
and the whole question of the letter, what the letter was saying, whether or not there was a count, was heavily canvassed.
What I do say, and we can get to the end of all the transcripts, the cross-examination, that it was never put to my client that this was a genuine account, nor was it put to him, did the account still exist, how much was in the account. The sort of basic questions, frankly, you would expect counsel to put if they were claiming that this was a genuine account. But can I come back to the transcripts and then we'll deal with the production of the letter and what was said then. And then if we go then on to page 229, where you can see that the letter was in fact produced from Mr. Hussain, who had it in his office in Bahrain. And that's at 229. Does your lordship have that? And my client was asked whether he'd read it. He said he had. Mr. Blade said, "Is this the only letter to the best of your recollection referring to monies deposited in your name by the bank?" And he says he thinks that later, I think that another letter, perhaps in the Portuguese bank later that year, but once again the letter was never utilised.
You said in opening that he was never asked about the second letter, but we've then got a page of him being asked questions about the second letter. So I'm just
Yes,
not...
what I said was that it was never put to him. He was never recalled once the second letter was.
Why would he need to be? What would he be asked? He was said that he thought it was there. He said what its purpose was for, and that it hadn't been used. So what would be the purpose?
The different number. There were two letters, as your
But
lordship.
they're different amounts.
They had different amounts, and it should, in my submission, have been put to my client as to why there were differing amounts in those letters and where the monies had gone.
But my lady makes a very good point. This morning you expressly said to us he wasn't asked questions about the second letter.
Well, then I put it inaccurately. He was never recalled and questions were not put to him after the production of the second letter.
Well, I think we know he wasn't recalled because that's one of the disputes between you about
Yes.
whether he should have been, and if so, who should have recalled him. But if you look up from 229 onwards, he's asked in some detail about the second letter, and it's put to him that Mr. Hussain must be lying at the bottom of 230, I think. And he accepts.
Well, yes, can I just pause there? What it's actually put to him is the first letter, it's dated the 30th of June. We confirm that you, i.e. Mr. Sultan, have at the date of the...
No, I can read what it says. I was actually putting a question to you which you asked me to pause, so I am, but it wasn't in the expectation you'd read something out to me. I've got open in front of me.
I'm so sorry, my lord.
Right. It's put to him Mr. Hussain's lying at the bottom of 230, I think. Is that right? It's put to him that the letter says there are funds and Mr. Hussain must be lying because the funds are not available.
Yes,
Yeah.
it's dishonest, is what Mr. Glazer puts, because those funds were not available.
Yeah, and then the next line below that, last line on the page, Mr. Hussain is lying in this letter about the funds being available, which he says is a simplification.
Yes.
And then it's put to him that Mr. Hussain must have put his name to a letter which was not honest, correct. That's just above letter C.
Yes, I can see that.
And he says that's correct.
Yes, and then it goes on, and then when it says there are 5 deposits, that is also dishonest, according to you. So the thrust of Mr. Glazer's cross-examination was that this was a dishonest...
Yes.
But both letters, in fact,
Well,
were.
again, that question is not Mr. Glazer putting a case, it's trying to establish, clarify what your client's case is. According to you now, it says.
And as I'm going to demonstrate to your lordship, it culminates in Mr. Glazer putting to my client that it was a sham, And that we find
Yep.
at the bottom of 232
Thank you.
at letter F. It's a document created between you and Mr. Hussain. It was a document, correct. It was a document that was created in contemplation of. Yes, it was a document created between you and Mr. Hussain. Once again, part and parcel of the contemplated series of transactions. And the intention behind it was to create the appearance for third parties that you had money. Yes. And my client responds, the intention would be effectively to provide a letter at the end of the day.
Yeah.
Once again. So it's put to him that it's to create the appearance of third parties and that he had money.
Yes, and the judge then clarifies that a few lines later by exploring whether the bank, excuse me, had, as the judge put it, $20 million sitting to its credit somewhere. The answer is the bank has liquidity. The judge pursues it. Did it have 20 million liquidity? Mr. Saints, the husband says it did, and then he's asked in cash, and he confirms in cash.
Yes, but the nub of it, if your lordship comes over to page 234, is when Mr. Glaser puts to my client, firstly, it simply helped, this is what my client had said, firstly, it simply helped us to achieve certain regulatory reporting requirements. That was to show, forgive me, to regulators, with the intention, you to say it was never used to show to regulators that there were certain amounts of deposits made by people, customers of the bank. There was a structure that would have been, yes, and that would have been dishonest, wouldn't it? Because you were saying to the regulators that their deposits were in your name, but in fact were circular. So that was in accordance with my client's explanation that there would have been an account in his name, backed by a loan and a blocked, as it were, deposit. And then if we go then please down to page 235, Mr. Glaser, can I work on at F? Can I work on the basis what this letter says? Not whether you used it or not. Can we just concentrate for a moment about what this letter says? Yes, this letter on the suggested suggests that you have deposits when you don't. Can you answer the question? This letter, yes or no? Sir Jonathan, the answer to the question must be yes, if you say so. Well, no, it's not what I say so. It's not, even though it might sound like it. What is the answer to Mr. Glaser's question? This letter would seem to suggest that I have available funds of 20 million. And then this is where Mr. Glaser puts his case. And this is a sham letter because you didn't, as at the date of the letter, have 20 million in the deposits which were available. Correct. And if I might pause there, sham was the argument that Mr. Glaser was running in respect of the fact, as you probably know. And my client's response, the deposits didn't exist because the structure had not been implemented. Mr. Glaser, and the funds, more importantly, were not available if it had been created because it would have been in a blocked account. So there are two lies. The first one is that the deposits were created. My lord is looking confused. Mr. Sultan accepted because it would have been in a blocked account. It would have to be back to back. They were not available funds that this man could draw out. And Jonathan says, well, why would it have been a blocked account? My client responds, the money would never leave the bank. And then again from Mr. Glaser, precisely. So it's never, that was the answer this man gave right at the beginning of this morning's evidence, that it was not available money, and therefore this was a sham, wasn't it, Mr. Sultan? Perpetrated by you and Mr. Hussain, which had you used it, I mean, there's a question about whether you did or did not use it, but on its face, this document has the appearance of creating legal rights which are different to what it says on the tin. Answer, my lord, the intention was not to. The intention was to try and see how we could participate in the bidding process. So there is Mr. Glaser putting fair and square to my client.
I wondered how much weight should be attached to the word available in that paragraph. Was Mr. Glaser putting that it wasn't available money?
Well, no, what he was putting was that...
Well, he was saying it wasn't available.
This was a sham, wasn't it, Mr. Sultan? As he had said earlier, that there were two lies in respect of the letter.
Well, on availability, it's dealt with in more detail at 238, isn't it? I mean, first of all, the judge at letter B explores the 20 million.
Yes.
And the witness confirms his first answer was correct. And then the first question from Mr. Glaser against letter D is, so they were never available, and that must mean the 20 million deposit.
Yes.
And it's confirmed by the husband. Those funds wouldn't have been available. So the distinction between existence and availability, you have to look in about 3 or 4 different places to draw
I
the
understand
threads
that.
together.
But the whole thrust of the questions of Mr. Glaser at page 236 was that it was a sham. And again, at page 240, at B, what we needed then was 20 million odd. And I know what we needed was 20 million odd million. The letter inelegantly was part of the thought process and of the structure which was never executed because of the inelegance of the structure and all the now ramifications associated with it. Still meant though, as we were to have aspirations for other banks in the future, we needed to show that the available and the inaudible allowed us to delay that. When you say inelegant, it's another way of putting dishonest. And my client again repeats that the letter was never relied on, the representations to a third party were never made. And so it was never, there was every opportunity for Mr. Glaser to put that these accounts were genuine and that my client had access to them. And then so unless your lordships are able to point to me, there wasn't a single question directly putting to my client that this was an account which existed and which he had access to. Nor was it put to my client, because he wasn't recorded in respect of the second letter, what happened to some $3.5 million, which was the reduction in the numbers in respect of the two letters.
When was the second letter first mentioned?
By my client, as your lordship.
At that point we saw.
At that point we saw.
After an adjournment.
After the adjournment, when the first letter was produced, he was asked whether.
So back on page 229.
And he said he thought there was.
Another letter, perhaps.
Yes, he didn't know whether it had been signed.
That's the first reference to the second letter.
Yeah. He said he wasn't sure whether there was one or not. So, my lord, we asked the question, why wouldn't, if that was the wife's case, why wouldn't that case be put fairly and squarely to my client? As I say, it was never put to him that the accounts existed and were genuine. On the contrary, it was put to my client repeatedly that the letter and all letters were dishonest and a sham. And then at that point is really made by Mr. Glaser at page 248 at E, if I might take you to that. Mr. Glaser, because I will be saying, like the cash account and like various other transactions, that this is an artificial way of inflating the assets of the bank. So there it is. That was the culmination of his cross-examination. The judge said, quite unusual for a wife to be saying the husband is overstating the value of his interest in the company. Mr. Glaser, we will come to that if I may. You can't trust these accounts. You cannot trust these accounts in the same way that the husband is effectively admitted with Mr. Hayne to have a sham document in relation to the 22 million. So that really makes my point for me. So, as I say, it wasn't put to my client that the accounts were genuine. It was put to them they were dishonest and a sham, even to the surprise of the judge at page 248. Can I then move on to the cross-examination of Mr. Hussain? And I say that also gives further force to our submission that Mr. Glaser at no point put to my client that these accounts were genuine. So if we can please go to page 259 and 260. Mr. Glaser cross-examines Mr. Hussain about the fact of the two letters. Now, Mr. Sultan said yesterday he believes there were two different letters. One was drafted and then this one. What's your recollection of how many letters were produced? Two. When were they produced? In June 2022, produced in June 2020? No. The first one was produced in June 2020 and the second one, I think, in November 2020. Right. Were they both produced by you? Yes. So do you have a copy of the November 2020 letter, some on your electronic systems? Do you want me to make that available to you? It's exactly the same format, the numbers are slightly different, but on the whole the value should read similar. Why are the numbers different? Because the letter had to be a refreshment, and therefore between June and July anybody looking at it would expect there to be a change. So you changed the numbers on the November letter, yes, to give the impression these were genuine accounts with movements on them, correct. And then at 261, perhaps you ought to start at the bottom of 260, who was the intended recipient of those letters? It would be the seller of a bank who'd want to know whether we had the wherewithal to purchase the bank. And who was the seller? It would have been something, I think it's Commercial General of Portugal. And would the regulators have wanted to see the wherewithal? No, not at all, but they would have looked at the bank's ability to purchase. So the intended recipient, and it's in their authority to ask. So there's a real risk that the regulators would have seen these letters. So they were intended to be read by the seller of the Portuguese bank. That would have been, I presume, the intention. And when the discussion took place between Ms. Salter about producing this, well, it would have been before June 2020. And did you then have another discussion in November 2020? Yes, we would have. Why did you need to produce a second letter with different numbers? And then the answer, because I think by the time we got doing the second letter, there was some movement had taken place. We changed one of them. I think one of the US dollars were changed. And so and then over in to page 262, and again, consistent with the cross-examination of the husband, it was the following exchange took place, starting at D.
Just to read on from there.
Sorry, forgive me, at C.
On 262 or 261?
262 at C.
Thank you.
Do you want us to read that page?
Yes, and what it culminates again, is the cross-examination consistent with that of Mr. Sultan, that it was put again to him that Mr. Hussain had created a sham document. Yes, Mr. Sultan knew it was a sham. Mr. Sultan was not deceived by the letter. He knew, and the question was, he knew it was a sham. And then over the page, and then you created another sham document in November, correct? Again, with the intention to deceive. And the answer, if it was read by anyone, they would be misled, yes. So, again, it wasn't put to Mr. Hussain that it was anything other than a sham letter. And then 266. When he was dealing with his statement, with Mr. Sultan's statement at E. What Mr. Sultan says is it was done for two reasons. Firstly, it simply helped us to achieve certain regulatory reporting requirements instead of gross deposit targets. And secondly, it allowed us to present the accounts as reflecting sufficient funds to support a bid we made to acquire another bank. So he's saying the letter was used not just for the seller of the Portuguese bank, but to show the regulators that you had lots of money on deposit. That's what he said. Yes, but it wasn't correct in that it was not what was done. But no, that's why it was produced. No, the letter was produced that. If we had taken the steps that it describes in my statement, the effect of that would have been to gross up the balance sheet. And then further question, yes, he's saying to use that letter to pretend the assets of the bank were bigger than they were, but he didn't because he couldn't. And again, the suggestion was it was a dishonest letter. And then please, if you travel to page 273, the allegation of sham is put again at little f. Now, do you accept, like the first letter on your case, that the second letter is also a sham? Unfortunately, yes.
I'm sorry, I was making a note on a different page.
273 at E.
Thank you, Ms. Bangay. Yep.
So you must accept, like the first letter on your case, that the second letter is also a sham. Unfortunately, on your case now, an intention to deceive another bank. And so Jonathan, it would certainly, could be an intention to see if it was ever produced, could it not? It would have misled anyone, had we shown it to anyone, yes. But the intention on its production on your case now was an intention to mislead another bank. It was to mislead anyone who read this document. And then, to be fair, the only reference
What about the question at the bottom of page 274? Just beyond F. Now, there's another possibility, Mr. Sayre, that these accounts
that's
are
genuine, yes.
true.
That.
It's a
I
possibility.
said, to be fair, I needed to put both these. There's no possibility whatsoever. Well, you wrote a letter saying what, so you must have been saying it's a possibility. It's absolutely not a possibility. And let's explore in a little more detail. And he refers to, over the page at 275, to Mr. Sultan's statement, and then further down, he says, the first letter, as you know, our case that Mr. Sultan has other sources of money, family trust, general funds, but other resources. You know that's our case, don't you? Yes. We know you wrote the letter saying you had 90 million.
That's the first letter.
Yeah, the first letter. but it was never directly put to him that this was an account belonging to Mr. Sultan. And
Well, this line of questioning is all in the on the proposition that the accounts exist, isn't it? This line of questioning.
yes, well, he asked the question, he said, no, there's no possibility, and Mr. Glaser moved on.
Well, doesn't he move on to asking questions about the second letter and Mr. Ferreira on the same basis? Or am I misreading?
Ferreira was the
First letter.
accountant,
Sorry,
not the second
sorry, my mistake.
letter. And he asked a few questions about that. But again, as I say, it was never put to him, but I ought to take your lordships finally to page 278.
This is the decline of $3.5 million.
I'm so sorry.
Is this the question from the judge about the decline of $3.5 million? 278 letter F.
278, yes, that's right. I don't recall, my lord, why it changed its name. Why it changed its name, I wish I did. What's the explanation due to any of these changes? All of them show, apart from the first account, show an increase. I wish I could recall, it would make my life a lot easier. And he says, my lord, I don't recall, I wish I could. I've agreed on the author of these letters. I've told the court the numbers are not based on any reality. These letters were disclosed because Mr. Sultan thought his wife may have seen them. An explanation was necessary. Had he not thought that, these letters would never have seen the light of day. So, well, I'm not sure where that gets us. These letters have no bearing, my lord, except Mr. Glaser intends to embarrass me to the extent that you may not believe any of the other transactions on the judgment. Sir Jonathan, I think the suggestion is these letters are the truth. They're not the truth, unfortunately. Then
So the judge interpreted Mr. Glaser's questions as being posited on the assumption that the accounts existed.
yes, so that was the extent of it. But what Mr. Glaser failed to do was put his case to my client. My client had no opportunity of dealing with the second letter, nor was it put squarely to him, as I've shown you in the transcripts, that it was put to him that these accounts were genuine. Au contraire, it was put to him that the letters were dishonest and were a sham.
The
And
second letter was produced at the start of Mr. Hussein's evidence.
I think it's produced, yes,
During
his evidence.
start of his examination.
To be honest, it's 3 years ago and I can't quite remember.
And you
But it
told
was
me that was,
certainly produced.
that was the first reference you told me earlier. You told us earlier. First reference in the whole case to a second letter.
Yes. No, my
That
client
was the
said I took you to the passage where he thought there might have been a second letter,
Sorry,
but he
my mistake.
That's
didn't
it.
have it.
I only remembered 5
it.
minutes ago. Goodness
Yeah.
sakes, how you can remember
That's
3
at
years.
229.
Yes.
Yeah, okay. All right.
Can my lady and my lord look at the bottom of 278 and then to the middle of 279, please?
Certainly.
Thank you very much.
Yes.
Sorry to
Well, as I
interrupt
say,
you.
to be
No, no,
fair
fine.
to Mr. Glaser, I was going to put the extent of the case that he actually put. If I could continue. This is actually consistent, is it not, with the account being genuine, this money being there, and the reduction being given, and then there's cross-talk.
The judge
I
said
think that's a submission, Mr. Glaser.
And then we revert to a question, I think.
Yes.
Third line, these two letters are consistent with them being genuine accounts.
No. If you go to the question at the top, and your first witness statement, the only time you change about these, the past versus the future, the account that you gave in your first witness statement, the account that Mr. Sultan gave in his first witness statement about these accounts having been created, the two letters are all consistent with them being genuine accounts.
Which is what I just said, I think.
Yes. The only time they changed, apart from whether they're blocked or not, the only time changed when you get into the witness box, say, no, they were all a sham. The letter is a sham, the second letter is a sham. My first attempt was my first witness statement was an attempt to avert the course of justice by lying with Mr. Hussein about Mr. Sultan about concocting evidence. You had to create this big narrative. It's all a lie to explain away what you were saying to these people, that Mr. Sultan had 22 million or 20 million. I don't agree with your entire description. However, my lordship, I'm the author of the letter and it has no basis.
Read on,
No,
please, next.
I'm not going to in any way recommend that to anyone as a pithy question.
Patrick Hastings wouldn't approve.
The next
But
one
it does contain somewhere within it a positive assertion that the letters are consistent with them being genuine.
I said that's why I've drawn your lordship's attention to it, but it was never put squarely.
Read on.
Well, he was never asked questions about does it still exist, what is in the account, all the sort of questions that, frankly, I would have put to that witness if I was asserting that the account was genuine, and I would certainly have recalled the husband and put that case to him, because the case put to the husband was that the whole situation was a sham.
Is it your case that it's not clear? It's
So-
not clear from that long question, or it's not really a question, it's a series of assertions by Mr. Glaser. Is it your submission is that it wasn't clear from that his case was these accounts were genuine?
No.
Can my lady and my lords look just a few lines down until the end of F, because I think D, E and F are important in that context.
Well, if Mr. Glaser is referring to Thurlow Square,
No, it's the and that's because Mr. Sultan does not want the court to think that he, the husband, has a lot of money. That's why they're creating this idea of a sham.
We can read it.
Sorry.
Okay.
well, as an aside to that, I put to the wife, and she accepted, that she could point to no source of funds that Mr. Sultan had in the summer of 2020 other than the bank. And, lady, may I ask this question, or perhaps pose this question? If this account had existed, why, if my client had substantial funds, would he be seeking to borrow funds from the bank in September 2020 to fund the Thurlow Place purchase? And as I put that to the wife in cross-examination. Also, and I know this trespasses on the appeal, why, if the bank had the funds in the husband's name, did it not insist on the repayment of the FAP in 2020? And why was no question posed to the SJE, who was preparing a valuation of the account and the liquidity available to the husband? Why was a question not posed to the SJE if it was thought that the husband had any accounts? And also, we don't have them in the bundle, but why were there not any related party transactions in any set of accounts around that time referring to an account of my client? So they are all questions which should have, in effect, been put or thought about in my submission by the judge when he came to do his judgment, but I'm slightly running ahead of myself. So, and my lords, can I remind you that Mr. Hussain wasn't, of course, the wife's witness. He was his own witness in respect of other matters. Sorry,
It wasn't the husband's witness.
so it wasn't the husband's witness, no.
It was me who called Mr.
Yes.
Hussain as a witness for the bank.
Not the husband's.
And I do not resolve from my submission that if Mr. Glaser was going to put to my client, or was going to make the submission to the court, that these monies belonged to my client, then he should have recalled my client after the second letter, after Mr. Hussain's cross-examination, and after the second letter was produced. But he did not do so.
I think you mean ask for you to recall it.
Yes, why should I recall my client? I can't cross-examine my client.
Well, the husband isn't compellable, is he?
Well, he was
Is he
already
already-
on the stand, as it were. He'd already given evidence.
Well, if he was actually in the witness box, he wouldn't have to be recalled, would he? You're talking about after his evidence has ended.
After his evidence ended, it was open, and it happens in trials, we've seen it. It was open to Mr. Glaser to recall the husband to pursue a different line of cross-examination. But he did not do so.
Well, I'm not going to waste any more of the court's time with semantics, but he wouldn't be recalling him because he hadn't called him in the first place. You'd called him, haven't you?
Perhaps I'm misunderstanding.
You're asking for him to be recalled.
One would have expected Mr. Glaser to ask for the husband to go back into the witness box so he could continue his cross-examination, particularly in the light of the second letter, which was never, of course, put to my client, or the allegations that it was anything other, the arrangement of these letters was anything other than a sham or dishonest. And really what we say is that the corollary of these principles that we've looked at is that it's not open to a party to advance a new case in closing submissions. And if Mr. Glaser was going to be suggesting that he was going to be making that submission, he should have given advance notice of it. At worst, we say at worst. And at best, he should have asked for the husband to go back into the witness box to continue his cross-examination. This point shouldn't be controversial. We've cited the BASF case. I don't know, whether the court is conscious of it, shall I take your lordship's briefly to it? It's in the authorities bundle at page 585, paragraph 285.
Tab number.
17.
Actually, it's 586, yes, at page 285. May I just ask your lordship to read from paragraphs 285 to 289? Two points arise from that. It's simply not open to a party to run a case where the other side has not had an opportunity to deal with it properly, and the obligation is on the judge to ensure a fair trial. And there is no obligation, I'd repeat, from my client's perspective, to, as it were, recall or volunteer him to give further evidence. It's if the wife wished to put her case in a certain way, she should have asked for the husband to return for further cross-examination. Can I then move on and deal with adverse inferences? And I have in mind paragraph, in Moha, paragraph 5, page 515, paragraph 75. Tab 16, Mr. Will's telling me. And I always ask the court to have this in mind, particularly when we come to look at the judgment and what the judge did or didn't do. And then paragraph 76, in particular, can I draw your attention to paragraph 7? There must surely be a sound evidential basis for reaching a conclusion as to the scale of undisclosed assets. The court should not be led into a knee-jerk reaction, let's say simply because evasiveness and opacity is demonstrated, there is vast sum salted away. This is not to say the court has to put a precise figure on the scale of the hidden assets, let alone to identify by reference to evidence what they are or what they comprise. That said, analysis of the cases shows it will always make a broad, sometimes very broad estimate based on admissible evidence of the scale of the hidden assets. Paragraph 15, of course, the court must be careful to note, to ensure that the note of caution I've sounded doesn't give rise to a cheat's charter, as Dame Elizabeth Butler-Sloss put it in Baker and Baker. Be wrong if the more usual consequence of the application of the principle was for adverse inferences to be too conservative, with the result that unfairness is in fact visited on the claimant, giving rise to what might be termed as a non-disclosures dividend. I accept the court must be astute to avoid this unfairness, and that a strong message must be sent out that a non-disclosure should not be able to procure a result from his non-disclosure better than that would be ordered if the court were told. But the court must be realistic, and there must surely be some findings soundly based on admissible evidence of the broad extent of the hidden funds. And the short point that we make in terms of adverse inference is that there's simply no evidence to suggest that the husband withheld relevant documents. He disclosed in his statements, in 2020 and 2021, that a letter existed. As I said, the irony is if the husband hadn't referred to the existence of that letter, we wouldn't be here now, but he was perhaps a victim of his determination to make full and frank disclosure. He hasn't been asked to produce the letter. The wife accepted his statement. It was never gainsaid. And when the judge said that there was no excuse that he should have produced them, my lord, first of all, first letter he did. He was never asked to produce, and the second letter he wasn't even sure whether it existed. And that was, of course, produced by Mr. Hussain. There was no suggestion also that the husband didn't make full disclosure in response to a lengthy questionnaire. I've already pointed out there was no schedule of omissions that related to any of the answers that he gave. And the wife was given, as we've already seen, the opportunity to plead conduct either before the FDR or it was available to do so any time thereafter. And it was disavowed at the outset of the trial that she was alleging a hidden account. May I also turn to the case of Moher, tab 16, which is a case your ladyship will recall, no doubt, page 515. Oh, I think, sorry. I think
Just done that.
Forgive me. We have, forgive me, rogue reference. I'm so sorry. But we say that that properly summarises how the court should approach the findings of adverse inference, because this was a plain finding by the judge of an adverse inference. And we say the real headline point that such inferences must be drawn on the basis of a properly pleaded or disclosed case, not one articulated for the first time in closing submission. Can I then move on to deal with the second ground of the appeal, which is that the judge's conclusion was plainly wrong, and we say contradicted by other findings, and as I said in opening, rationally we say unsupportable. And really the starting point to that is the relevant facts as it relates to the husband's financial position as to his assets and resources. And I'm going to try and say whip through this relatively.
Yeah, well, we have course, Reggie's got an argument and so on.
Right. Well, if I
I'm
perhaps
conscious of time
summarise
for
it
the
as
other
briefly as possible, the judge was in the unique position of knowing what this husband had at the end of his first divorce, which was some 8.5 million.
Yep.
We know that he started a bank and didn't get any income from the bank, and the bank was, his share in the bank was in part funded by a loan from his father. The judge also knew, or ought to have taken into account, that between 2014 and 2015, my client was involved in ferocious litigation with Mr. Akbar, and that is of particular importance because it culminated in a trial in July 2020, and the result of which was not received until the October. It was accepted by the wife that the husband had run out of money in 2018, that he borrowed money, and that in 2019 the husband had had to borrow, as it were, from the bank to fund his lease extension. And so in 2020 there were no contraindicators when these letters were written that my client had any access to any funds, or more critically, that there had been any liquidity event that could conceivably created a fund of some $20 million. And in my submission, those are facts which Sir Jonathan Cohen did not give sufficient weight to when coming to his decision. And if one please, what we say is that in summary, in the summer of 2020 or any time that year, there's no basis to find that there could have been liquidity event. If we go to paragraph 98 of the judgment in the core bundle, paragraph 98, as the judge recognised, he said this. He said it was impossible to recognise these letters with the husband's apparent illiquidity in the period of 2017 and 2019, the reasons already set out. Whether some fortunate event happened in 2019 and 20 is surmise, and that's precisely what it was. And as I referred earlier to the questions that I suggested the judge ought to have asked himself, I'm not going to repeat that. And nor did the judge in particular, we say, take into account that the audited accounts which he had, I think, between 2018 and 2022 showed no reference at all to there being any related party transactions, and if the husband had a significant holding of cash in the bank, that it would have shown up. And of course these were accounts that were all audited. And at page 104 and 105 we come to the nub of the decision. I've wrestled with this issue.
Paragraph 104.
So, forgive me, page 86, paragraphs 104 and 5. I've wrestled with this issue the hardest in the case. Are the letters part of a presentation by HIIB to others being a man of entity of substance, a man or entity of substance to present an exaggerated position of wealth, or are they the truth? I look at the totality of the evidence, including the accountants, and asked myself what is the most probable explanation. Have two highly qualified individuals written letters setting out the truth, or have they written what are deceptive, dishonest letters? In either event, they admit that they then wrote statements verified by statements of truth that were untrue. The repeated lies about these letters, together with the factors set out at paragraph 2094, persuade me that they are more likely to be true than false. If I'm in error, he only has himself to blame. And well, what we say is that the judge limited himself to a very narrow consideration. He focused on the letters, and he did not properly take into account what he had recited to himself earlier in the judgment was my client's impecunious position 2018, 2019 and in 2020, when it wasn't suggested that my client had access to any other income or funds other than his salary of $425,000, which the judge refers to in his judgment, which commenced in January 2020. Lord, we've been through, I think, the evidence relating to the disputed accounts. I don't think it's going to help if I re-rehearse that. May I just say this, that as to the two letters, and I don't know if your lordships have looked recently at the letters.
This morning.
They do, of course, on their face refer to an account, and the fact that the second letter shows different figures to the account, that it's important to emphasise, other than those two letters, there is not a single piece of evidence anywhere, whether in the accounts or otherwise, to suggest that those accounts existed. And both the husband and the author of the letter have given explanations to why the letters were written. I cannot but accept that their evidence was unsatisfactory in certain respects, pointless to do otherwise, but their absolutely consistent position throughout is that there was never a genuine account from which my client could access cash. And as I perhaps repeat, there were no questions to my client as to the genuineness in this account or where the funds might have come from. And the fact that the husband and Mr. Hussain lied in their statements about the existence of the accounts, in my submission, cannot be determinative absent any other corroborating evidence. Turning to the submission stage of the case, had Mr. Glaser, even at 6:27 p.m. the night before, set out the case that he was intending to run, I would have addressed it in my submissions. My sketched out position, my bullet point submissions are there for the court to see. It wasn't an issue that I dealt with, nor was it an issue that was put to me by the judge.
Just remind us of the reference to where your submissions are, please.
Yes, they are in the authorities bundle. Forgive me.
Supplemental.
The supplemental bundle.
Thank you.
And they are, closing bullet points are at page 51. Part of that was Mr. Wheel's submissions in respect of the FAP. The other part was myself in respect of what I call the more pure matrimonial elements. And the only basis on which we dealt with the letters was in the context of the husband's credibility and not otherwise. And it's open to the judge, if he had it in mind, or if his thinking was that these accounts might be genuine, to have at least put that during the course of submissions, and then I might have been able to deal with it. It wouldn't have been satisfactory, but it would have been something. As to the questions that the judge posed in his judgment, paragraph 94 questions. He asked a number of questions in our skeleton. He asserted in his draft judgment that none of these questions had been answered, and we took issue with that in our request for clarifications, and the judgment was amended to say that none of these questions at the top of page 83 were properly answered. And the judge said this has been the most puzzling aspect of the case. Why, if these letters were never used, were they both signed and dated? Well, in my submission, my client did give an answer to that question, in that he explained that there were two deals, and that the letters were to, as it were, big up the balance sheet. And then the next question was why they were prepared in the first place if the circumstance of use had not yet arisen. Well, the deals were in contemplation. One was in June 2020 and the other in November 2020, but neither deals went ahead. And then he asked why there were two separate letters not used by November. What was the point of the June letter? Mr. Hussain was unable to answer that question. Of course, it was never put to my client. The answer was that the financial needs for the bids were, of course, different, and that really accounts for the following question as well, the next three questions. And then at the top of page 83, he asked the question why these letters were never produced earlier. He said the answer given that they were not answerable carries no conviction. Well, lady, I think I've dealt with the disclosure point, that we were never asked for the one letter that my client did understand existed. So the bottom line is that the only evidence the judge had to go on was the two letters. The case that the accounts were genuine was not put squarely to my client, on the contrary, that it was a case of dishonesty or sham. And in our submission, that was not a rationally supportable decision. And perhaps one might look at this on the flip side. If my client doesn't have the 12 million that was suggested, and if this order were to stand, what would be the consequences? The consequences would be that the wife would seek to enforce it. There are no assets in this jurisdiction. My client would be made bankrupt. His position at the bank would be untenable, and he would have no income from the bank, and two families would in effect be unsupported because he wouldn't have an income.
So your proposed remedy would be allow your appeal and order a retrial?
Well, I've thought about this long and hard, and I suspect I speak for all on the front row. Nobody in this case would want a retrial.
Well, I think that nobody on this bench would wish that either.
But what I have come to is this, having given it some serious thought, is one, the order should be set aside, and to remit the case for a further hearing to recompute the award on the footing that the disputed account does not exist. And the case would inevitably be allocated to a different judge, and the judge would be tasked at that hearing to case manage the appropriate directions, whether for revaluations of property or the bank.
But that would be on the basis then that your late client would be saying he has nothing.
Well,
And so the wife and the children would have nothing.
well, lady, as I've said, the flip side of that, if he genuinely has nothing, which he says he doesn't, and he is bankrupted, then it's perhaps even a worse scenario for both my client's first family, who he supports the extent of 100,000 a year, and the wife.
Well, I'm more concerned about, obviously, this court's more concerned about this wife one disabled child and one infant child who, on your submissions, obviously will be out on the street with
Well, Lady,
earning capacity.
my lady, she wouldn't, because we have the offer from the bank, whether that offer remains. But
Well,
she
it
wouldn't.
as I understand it, it doesn't, and they seek the discharge of paragraph 10, which also would, which Mr. Richardson's nodding, which inevitably would also lead to the discharge of the protection that's in paragraph 12, because they have to go together. Again, Mr. Richardson's nodding.
Well, that's right. But either way, it's semi-disaster.
I'm not being critical.
No, I
I think we
understand.
have to be open-eyed about the consequences of various different outcomes of the case, and I think each of us want to be clear about that.
The wife would have maintenance and would be able to rent. I accept.
Well, how would you have maintenance if you were saying your late client to be?
Well, lady, if the order was set aside, so my client doesn't have the 6 million,
Understood. Sorry.
she would
I
have
understand,
a maintenance award. And there's also, lady, my client does not know how the cookie's going to crumble on this one, but there is the hope, but not expectation, that Mr. Akbar may pay up in
31.
2031. On the same line, my client lives in rented accommodation and he's moved to lesser accommodation because of his straitened finances. He owns no home. This is a dire situation, whichever way, frankly, you look at it. But if the order stands and he is bankrupted, in my submission, that would be the worst of all worlds. But if it was remitted for hearing, the issues are fairly, I'm not going to say straightforward, but the issues would be easily formulated and could be appropriately case managed in a cost efficient manner by whichever judge was allocated to it. Jonathan,
Thank you very much, Ms. Thank you as well, because you've been asked many questions which you've responded to.
I'm so sorry.
No, I was
Mike.
simply saying thank you very much. You've been asked many questions which you've responded to carefully and courteously.
Yes, well, as I always say, being in the Court of Appeal is like being in front of 3 machine guns.
But with rubber bullets.
Fortunately.
These days.
Yes. So the bank. But just before you launch in, Mr. Richardson, I saw you nodding. So can I confirm that your position is that if paragraph 10 goes, so must paragraphs 11 and 12?
That's right, my lady, yes. We are then released from the undertaking in paragraph 11 because our undertaking in paragraph 11 only sits there until such time as we succeed on this appeal, if we succeed on this appeal.
And is the bank's position, and if you choose not to tell us, that's entirely a matter for you, but it is the bank's position that if the husband's appeal is allowed, and therefore there's the finding that there's 16 million available to him, that the bank's position remains that they have withdrawn their in principle offer of accommodation.
It is, my lady, yes. And I think I took instructions to say this, which is going forward, if the husband and wife can between themselves come to an agreement as to what the future should look like in terms of provision for the wife, and if that involves the assistance of the bank, in particular potentially in relation to rehousing the wife and children, then that is something we will give serious consideration to. So we do not, as it were, say, well, once bitten, twice shy. We've been bitten, as it were, by our attempts to assist at trial. But if we succeed on our appeal, we aren't saying we're never going to assist in the future, but it will require the husband and wife to put something agreed between themselves to us, so we're not sucked back into yet more disputes between the two of them, in effect.
Thank you, that's very clear, I'm grateful.
But can I just be crystal clear with you about this, because I want to make sure that I personally fully understand. That would mean, when my lady put the point to you about 10, 11 and 12, I think you just answered in respect of 11. You accept 12 would go as well, is that right?
No, I don't think. Forgive me. I think 12 stays. Yes, in fact, it's only 11. Our undertaking 11 that goes on the appeal.
So 10 and 11, the effect on the order.
Yes.
Would be 10 goes, 11 goes.
Yes.
But so far as the family home is concerned, the undertaking given by the wife remains extant.
That's right, my lord. Yes, I believe.
Give me a moment.
With the upshot of that then being that after this detailed hearing, there's no provision at all in the order for the family home.
That's right.
Can I just read that properly, my lord? I don't in fact focus on this. I think, my lord, and I'll come back if I need to correct myself again, I think I'm not saying that 12 goes. I think 12 isn't conditional, as it were, upon my appeal.
We'll come on to that in due course, but that was what I understood your position.
So
that's why I was asking.
You're quite right, my lord. So 11 goes, but I don't think if my appeal succeeds, 12 doesn't disappear immediately, and therefore we have to do whatever we have to do if we have to do it in order to seek vacant possession.
Which means the legal effect of those 2 or 3 different building blocks together means there's no provision in the order for the family home, because 12 requires or is an undertaking by the applicant to remove her restriction. So once that restriction's gone, there's no provision in this order to make any sort of housing provision for the family home, because her undertaking would remain.
That's right, my lord, yes.
So that would be the effect of
that would be the effect, yes. Obviously, my lord, we're then left with the property in which the wife with the 2 children are living, and it'll be a matter of the bank whether it can or wishes to obtain possession of that property, because obviously there's a disabled child and a minor child in that property.
Talking about the way in which the court would have resolved the proceedings, which include within them as an integral, some might say the most important, being somewhere for the children to live.
Yes.
Thank you.
Thank you for that clarification.
Not at all.
Now, let's turn to your...
Yes, my lady, my lords, can I just check first that you received, I'm afraid, some yet further supplemental documents from us, which should be right at the back of the second supplemental bundle. There should be a new page 706 and following. I just wanted that came in last week. I'm just hoping it's arrived with you.
Oh, is it in a separate file?
It may have come in a separate file from my sisters, in fact.
The little white file? No,
You do, in that case, you have it in a hard copy at least. I'm grateful.
the little white. Yes, thank you.
So, my lady, my lords, we've already effectively looked at what my appeal concerns. It's a narrow appeal, clearly, but we say an important one in principle, and one that's important to the bank, and it concerns, as we've seen, centrally paragraph 10 of the order. Yep. It's important to note, we say that provision effectively gives directions from the court, and those were given by the judge at the consequentials hearing on the 15th of December, to which we shall come. So paragraph 10, although it appears in the recital section of the order, it is not in fact an agreement, a recited agreement between any of the parties, and it wasn't agreed to by my client or indeed the husband, and nor indeed were its terms ventilated by the judge with the parties at the oral hearing before he gave his extempore oral judgment on the 15th of December, making orders in those terms, which I will obviously take you to. Now, we know obviously the final hearing took place in October 2023, with judgment being handed down remotely on the 28th of November 2023. And I'm sure you will have read the relevant, for my purposes, the relevant parts of the judgment of paragraphs 130 and 131. They're in the core bundle at page 89. Perhaps if we just turn that up very briefly. And you'll see the judge records there that at his instance, and with what he describes as a fair amount of judicial encouragement, Mr. Hussein agreed that IIB would be prepared to assist W in her desire to live in a house in Fulham, and then he sets out the terms, as it were, in terms of the purchase price coming from the net proceeds of sale of Belgrave Place. And in paragraph 131, he effectively summarises what I had put to him as the conditions that we attach to, all the requirements and terms that we attach to that proposal. That being obviously the FAP was ultimately declared to be valid. There would be vacant possession of Belgrave Place, the injunction and notice being lifted, balance of proceeds of sale reverting to us, that there be a lease or licence to occupy that would expire upon the end of the daughter's tertiary education, and there'd be provision for the husband to purchase the property from us at market value at any time. And that, my lady, was reflecting what I had in fact said to the judge. And if we can just look at that, please, that's in second supplemental bundle at page 709. Just going to throw it back into the transcripts.
The new skinny bundle.
Sorry.
I'm so sorry, it's in the new little bundle. You have the white
new
bundle.
bundle. My
It should be a
mistake.
slim white Ashford's bundle, my lord.
Yes. 709. I'm so
Yes.
sorry.
Not at all, it's me, I should...
Mine's not actually.
Oh, is it not? I'm so sorry. Well, in that case, internally, it's the first document, which is transcript extracts, and it's internally page 45 of that transcript.
That's behind tab 2.
I'm sorry you haven't got the page
No,
numbering in there.
apparently,
Somebody has been exceptionally artistic.
Oh, it's extremely small. It is.
Yes.
There is an
Found
awful lot of
a
zeros,
so small, none of us knew it existed.
and I hadn't even noticed it, so I apologise.
a million years ago, it used to be known as a Bruce Blair font, but I think only Mr. Bangay would remember. Bruce Blair font, the reference to tiniest fonts in the world.
Yeah.
So this was the very final day of the final hearing, and what happened effectively was the judge, having heard from me on I think the previous day and being dissatisfied by what I indicated the bank might do then, encouraged me to do better, as it were, and take instructions, and he re-encouraged me to do so during Mr. Glazer's closing submissions before the short adjournment, and effectively said, can you come back after the short adjournment and tell me if the bank's going to do something better? So you'll see I say that this has got me then at the top of this page saying, may I address you shortly, and that's after the short adjournment, hopefully. And the reason Judge did that was so that Mr. Glazer could have an opportunity to hear what I was going to say before he finished making his submissions. So I did take further instructions over the short adjournment, and we came back, as you can see, where it says court resumes on the following page. And that's where I say it's a slightly garbled transcript, but you can see at E, well, I'm saying that, D, I'm saying the proposals made on the basis the FAP is found to be valid, and on the basis that the wife will agree to give vacant possession voluntarily come a relevant date the following year. And then I say the bank is able to indicate in principle as follows, and then I set out what we set out by way of our proposal in principle at that time. That's what I said to the judge. He said, thank you very much, as it were. and then Mr. Glaser continued with his closing submissions. And I'm going to come back to what in fact, if you like, happened, but just looking at what we did and didn't do in what we said there, what we did do was what we said we were doing, which was making a proposal in principle as to what the bank would be prepared to do in order to assist with the concern that the judge had identified about the rehousing of the wife and the children. Now, that wasn't an undertaking to the court, and the wife didn't understand it to be, as we'll come on to see, and nor indeed to the judge, obviously, because the order doesn't record that we had given an undertaking. At most, that was an offer to do a deal, to contract with the wife, on the terms we were putting forward.
You said the order didn't record that it was an undertaking, but the order does say it's an undertaking.
No, my lord, not the proposal to rehouse the wife. The undertaking in paragraph 11 is an entirely different and discrete undertaking that we gave that was canvassed at the consequentials hearing.
I understand. That's what I said, yeah.
Yes. The actual proposal, we were not giving an undertaking to the court that we would buy a house for the wife to live in with the proceeds of sale from Belgrave Place. Yeah. And the judge understood that because there's no undertaking in the order, and my learned friend understood that, as we'll see from the skeleton arguments he filed for the consequentials hearing. So at most, all we can have been doing was making an offer to contract to the wife. Obviously, parties do not make contracts with the court. This was essentially an offer to deal with the wife on the terms that we were proposing. And that would have needed, obviously, to have been reduced to writing. And had she agreed to it, and had we reached agreement on those terms, then doubtless there would have been a recital to that effect in the final order, and the agreement would have been exhibited to that order. In fact, I say, we weren't even making her an offer, as it were, capable of acceptance so as to form a contract, because there were fundamental things still to be discussed. In particular, as I made clear in the transcript to which I've just taken you, the legal nature and terms of the wife's occupation. I had posited it might be a lease, or it could be a licence, it might also in fact be a tenancy. But we hadn't, as it were, even definitively proposed, let alone set out something capable of acceptance by the wife as to the legal nature of her occupation thereafter. That was something that we needed to discuss if we were going to take this forward with her. So it was, in my submission, not even an offer to contract with the wife that she could accept. It was simply a proposal that would require further deliberation and discussion. But if it was an offer the wife could have accepted, if it was capable of acceptance, if she had, as it were, bitten our hand off in Mr. Glaser's closing submissions, then we would be in a wholly different situation. But as we'll see, it was outright rejected by the wife. And instead, she demanded fundamentally different terms from us. We did not know that by the time the trial closed, because Mr. Glaser didn't respond orally in the course of the afternoon of the 27th to the proposal that I had put forward. We know, as it were, that it found favour with the judge in the sense that he thought it was reasonable provision for the wife and children, because he records it in his judgment in the terms that he did. And I say that was handed down in late November. But the wife's position had not been articulated, and it may be the judge thought, given Mr. Glaser had made no comment, that our proposal had found favour with the wife as well. But we know it didn't, because what then happened on the 5th of December, so after the judgment had been handed down, but in advance of the consequentials hearing, was that the wife's team, I think it was Mr. Haggie, circulated her proposed draft order that she was going to ask the court to make on the 15th of December. And that, my Lords, my ladies, again in the second supplemental bundle at page 385, if I could ask you to go to that. So the document here at page 385 is the draft order circulated on behalf of the wife to the other parties in advance of the consequentials hearing.
Dated.
It was sent to us on the 5th of December. It doesn't. I think it's not dated as it works. It's a draft of the order that's proposed and put before the judge for approval on the 15th. I will have somewhere the email by which Mr. Haggie, I think it was Mr. Haggie, circulated it to us, but it was their document coming to us in mid-December, as it were, or in early December, rather. Now, the point, my lords, my lady, is if we go to paragraph 10 in this document on page 387, this is what the wife was proposing the order should contain, which was a provision that if the respondent, the husband, failed to pay the lump sum by the end of the year, we would then undertake to the court to pay a lump sum equal to the cost of purchasing a replacement property for the applicant and children of the family on the terms set out below. Now, I don't propose to take you through all those terms, but they are fundamentally different to the terms of our proposal that we made on the 27th of October. Just picking out a few points, paragraph 13D provided that the replacement property should be held on trust by us for the applicant and the children of the family. No thought given to the terms of that trust, but we weren't proposing a trust. No thought apparently given to the potential tax implications of creation of a trust, but that was what was being, as it were, required of us. Somewhat surprisingly, given there was supposedly a trust arrangement, over the page at paragraph F, there's also a requirement that there be a lease put in place with a peppercorn, effectively, rent attaching to it. And that's to remain in place until one of the determining events, as they're put, which are either the purchase of the property from us, and we'll come on to that, the wife's remarriage, her death, or further agreement or further order of the court. Now, our offer had only been to house a wife and children until the youngest daughter left tertiary education. Again, fundamentally different here. Over the page at 15, a requirement that if she spent money on the property, she would acquire an equity interest in it. Again, difficult to see how quite that fitted with the trust arrangement anyway, but that was no part of our proposal. 16, a very complicated provision essentially requiring us to permit her to move to another property if she wished to do so, with a complex mechanism in relation to that, which was no part of our proposal. And then, most egregiously, at paragraphs 17 and 19, a requirement that she be entitled to buy the property from us at any time in the future for the sum that we used to purchase it, the £2 million that was anticipated. So not only were we not going to get capital appreciation on the property, or an interest rate for advancing monies to acquire the property, and our proposal obviously being that we get any capital appreciation on the property, but she was now to be able to purchase the property from us at any time in the future, and given this property would need to be held, even if it's only until the daughter left tertiary education, for 10, 15 years, that in 10 or 15 years' time, she'll be able to buy it for the same nominal value in money terms as our original purchase price. And I don't need to tell the court that £2 million today is worth a lot more than £2 million in the future. So she was asking for a very good deal commercially for her, fundamentally different to the deal that we proposed to the judge on the 27th of October. So that was what she was proposing. She did not accept our proposal.
That's contractually a counter-offer.
That's contractually a counter-offer, my lord, which we then contractually, if we are in the world of offer and acceptance, we rejected on the 12th of December by my solicitor's letter to Forsters. And that, my lord, is a few pages on at page 397. And you'll see there we refer at the top of the page, my sisters refer at the top of the page to the draft order circulated by Mr. Haggie on the 5th of December, and in particular paragraphs 10 to 20 regarding the replacement property is defined. We say the order as drafted fails comprehensively to reflect what was set out of paragraphs 130 to 131 of the judgment. And we also set out, we didn't have the transcript at that point, so we set out my speaking notes from which I'd read out to the court our proposal. We then note, and go on in this letter, to note that the judge's findings in relation to the blocked accounts and his findings that in fact the husband had a lot of money available to him immediately. And we effectively remake our original proposal to the wife, so we reject her proposal in the draft order, we remake our proposal, but with additional conditions, which is that now you've got the lump sum order you've got, predicated on a state of legal facts as found by the judge, as it were, which we happen to know in reality are not correct. We therefore know that if you seek to enforce your lump sum by way of a statutory demand or the like against the husband, you can force him into bankruptcy because he cannot pay. That's what we understand the position to be. And therefore we remake our proposal to you, but with additional requirements, which are you don't seek to bankrupt him or have him held in contempt, because that would affect our business, essentially. If we lose our chief executive, he's no longer able to be our chief executive because he's being bankrupt in this jurisdiction, and if foreign authorities therefore regard him as an unsuitable person to be in charge of a financial institution, we will have to shut up shop as a bank. Our creditors' interests come first, and we cannot be advancing significant monies in London for the wife and children to live in long term when those monies may need to return to our creditors. So we say to the wife, we understand you have a housing need. We're still willing to meet it on the terms of our original proposal, so long as you are not going to bankrupt or otherwise do something to the husband, which means he can't be our chief executive and we cease trading, effectively. So that was our attempt to cut through what we understood to be the consequences of the judgment. And that in turn was rejected again by the wife. If we move on, my lords, my lady, to her notes of the 14th of December, that's at page 401. And you'll see under paragraph 2, replacement property, it says the wife wishes, in accordance with what was said at trial, for IIB to purchase replacement property following the sale of the former matrimonial home. She seeks IIB to undertake to do so. However, if they will not, so she was quite clear herself there was no undertaking already given to the court, she seeks the court to record their agreement to do so, which she says, of course, is enforceable in the same way as an order. She then says, IIB now wish to resile from their agreement, and my whole case, if you like, on appeal here is that there was no agreement, as we've just seen, which the wife asserts they cannot, as it was proffered to the court, and was a basis upon which certain matters were decided. Well, I'll come on to that point, because that's a bad point too. It then says in 4, they're willing to continue to be bound by the agreement to purchase replacement property if the wife agrees not to apply for the lump sum order against the husband. For obvious reasons, she will not so undertake. As such, the order should record IIB's agreement as accepted by the court in the terms sought by the wife. And as I just said to you, the terms sought by the wife were fundamentally different to the proposal that I made on the 27th of October. There was and there is no agreement between between IIB and the wife as to the terms on which the replacement property should be purchased. And there was and is no undertaking to the court from my client. Now, just on the point about the lack of an undertaking, because it goes, if you like, to the court's jurisdiction, IIB was not at the final hearing in October because there was any question of its assets being available to the court pursuant to the Matrimonial Causes Act jurisdiction to make provision for the wife or the children. My client was joined to the proceedings and in court solely because the wife had asserted that two sets of assets in fact belonged to the husband beneficially. One was a Belgravia flat the family lived in, whereby she alleged the FAP, as we've been calling it, the Forward Acquisition of Property Agreement, between IIB and the husband, arising from IIB's financing of his lease extension, was a sham, and that the husband owned the property outright. The other was in relation to an employee share ownership programme, or ESOP, a form of employee benefit trust, established by the bank for senior employees, which she originally said was also in effect a sham, such that the husband beneficially owned the IIB shares held within that structure. Now, the former of those claims was fully tried out by the court at the final hearing, as you'll have seen from the judgment, and was rejected by the court. That's rejected in the judgment at paragraphs 52 to 56. It's obviously relevant to the wife's permission to appeal application, but the principal reason we were in court was her claim the FAP was a sham. That was tried and dismissed. The latter claim about the ESOP shares was not in fact pursued by the wife at trial. Instead, she reformulated her claim to a claim that not that the husband beneficially owned those shares, but they were a resource available to him in the matrimonial court sense. And that too was rejected by the judge at paragraphs 81 and 148 of the judgment. And can I just take you, so you see it, my lady, my lords, to how we put this in the skeleton. That's in the core bundle at paragraph 308. Because it was, as it were, a matter of chance that my client was at the October hearing at all. That is because until January of that year, January of 23, all the case management had proceeded on the basis that the two IIB issues, the FAP issue and the ESOP issue, were to be termed as preliminary issues in advance of the wife's financial remedy claim being tried in October 2023. It was only by an order of the 9th of January of that year that the court vacated the preliminary issue trial, which was due to take place in February, and listed the IIB issues to come on for the trial at the same time as a final hearing. And it did that because the wife's then counsel asserted that Forsters would be unable to continue acting if there were two hearings, if there was both the preliminary issue trial and a financial remedies trial in October, because Forsters were so out of pocket already, as it were, in acting for the wife. And essentially, Ms. Shum and her colleagues said, well, we'll bear the pain if there's one hearing, but we can't bear the pain if there are two hearings. And because the judge regarded it, unsurprisingly, as important that the wife was represented by leading counsel and Forsters at the financial remedy hearing, he abandoned the preliminary issue trial and we had just the one hearing in October. Had that not happened, any question of my client being asked to make provision for the wife simply wouldn't have arisen, because we'd have had a discrete trial in February about the preliminary issues and no more, and we wouldn't have been there in October to have any questions asked of us or judicial encouragement given to us. So I make that point just to say, to make a point, and then I suppose over the page at paragraph 10, I make that point, and I'm just making the point there that it's obviously very important to remember that the IIB is not a party to the marriage or the divorce or to W's claim for financial provision. The court had no jurisdiction under the 73 Act or otherwise to require it, as opposed to H, to make provision for W or the children from its own resources. W did not contend that IIB was a sham company or the alter ego over the husband, or that all its assets were held on resulting trust for the husband, as the Supreme Court found in the Crest case, or anything like that. And moreover, and importantly, given what's said in my learned friend's skeleton argument, the wife disavowed any contention that the former matrimonial home, or the FAP, formed a nuptial settlement for the purposes of section 24(1)(c) of the 73 Act. And that was disavowed on the first day of trial on the 17th of October, And again, that's in the new bundle that we've handed up to you. If I just take you to that, again, I think it's at page 706 to 7.
706.
Yes, it's tiny numbering at the bottom.
Thank you.
Now, if we pick it up on, it's page 707, the tiny 707, page 22 of the transcript. I'd raised these issues around my own friend's pleading, and Mr. Glaser says at line 8, obviously Miss Richardson should know, must know my position about that. I think we're here talking about the nuptial settlement issue, but I hear what's said, as my lord knows, and it's clear from the documents we filed and the evidence my client has filed, our principal primary case is sham. And then there's the assertion that we won't in fact exercise the rights that we have. And then Sir Jonathan says at line 19, that's fine, but I'm just concentrating on variation. That's a nuptial variation claim. Yes, he says, I do not regard a line and a half in the defence pleading, if that's the only reference anywhere of variation of nuptial settlement, yes, in these papers as a proper basis for going forward. Mr. Glaser says, no, I completely understand that. And Sir Jonathan reiterates his point at line 28, and then says, my lord, Mr. Glaser says, my lord, we completely understand. If our position is anything other than that, we will tell Mr. Richardson, but otherwise he can work on the basis, if he wishes, that it's not going to be pursued. But if he wishes me positively to say that, I'll take instructions, and Mr. Jonathan says, I'm sure he does. And that's why I think I need to take it there, because what I think Mr. Glaser did come back and say, no, we're not running a nuptial variation case, but in any event, he didn't run a nuptial variation case at trial. There was no suggestion that there was anything here that was capable of variation pursuant to the court's jurisdiction. I'll come back to that point in addressing my learned friend's skeleton. Now, in that context, my lords, we say it's entirely unsurprising both that we didn't give an undertaking nor the court sought one from us in terms of the wife's and children's housing provision. Ubiquitously, if not always, parties give undertakings to the court in relation to things that the court has jurisdiction over them in relation to, and the court can make orders against them in relation to. The court had no jurisdiction in relation to us, and we did not offer an undertaking.
Well, the court can't order parties to give undertakings anyway.
No, quite, but often they're given as opposed to an order being made. Quite.
What an order does in that situation is it records the promise that the parties made to the court.
Quite, my lord, yes, exactly. But we made no such promise to the court here, and the order records none. Now, my lord, we're then coming back to the consequentials hearing on the 15th of December. I've taken you to my learned friend's note for that hearing. We also obviously produced one which addressed why we said the wife's 5th of December draft order fundamentally departed from our proposal. I don't need to take you to that. I've already taken you to our 12th of December letter to Forsters in that regard. But during the oral hearing, Mr. Glaser continued to press his order on the court, as it were, and was seeking for the court somehow to make an order that IIB had agreed to rehouse the wife on the terms that she set out in her draft. It was that that led to my submission to the court that there being no agreement between the husband and the wife that was in place, and if the court was unwilling to adjourn the hearing to see if we could make further progress in discussions, which is what I suggested to the learned judge, which he was unwilling to do because he wanted to make an order on that day, and he was seeking to make an order that dealt with everything, in effect, including, of course, his concern about the housing of the wife and children. So he refused my suggestion that there be an adjournment of the hearing to see if we could make progress on negotiations, which led me to submit to him that in that case his order was quite straightforward because there was no agreement between my client and the wife to make any housing provision for her and her children. He had no jurisdiction to order my client to do so, and therefore he could simply scratch out of the 5th of December draft all the paragraphs from paragraph 10 onwards that Mr. Haggie had circulated, which set out the supposed proposals and terms upon which we were to provide rehousing. Now, I don't propose to take you through all of that, but just so you have it, that is in the second supplemental bundle. My submission is the second supplemental bundle, at page 433 to 439. Again, unless you want me to, I won't take you to that, but that's for your notice, it were. That's where I was saying to the judge repeatedly, there is no agreement, you have no jurisdiction, your order is in fact therefore very simple and capable of being settled today very simply. What then happened, as we know, is the judge went on to deliver a short judgment orally. That's also now in our little white file. I think it's the final tab in that, pages 711 and onwards. So this is the transcript of the judge's extempore judgment. And you'll see at paragraph 2.
Sorry, I don't seem to have that.
Oh, it should be the final document in that little clip.
Mine.
Tab 3.
I have a tab 3, but it's empty.
Well, I hand up another copy in that case.
That'd be great, thank you. Thank you. Yes, I have that now.
So it's paragraphs 2 to 7, in effect, where he deals with the proposals. In paragraph 5, he recalls, if you like, the substance in a very pithy way of my submission to him, which was my clients have made an offer, it's been refused by the wife, she's made a counter-offer, the bank has refused that, and there's nothing upon which the court can bite, as he says. And then the judge says, I do not think it's as straightforward as that. The offer's been made by the institution in which the husband is a 60% shareholder. True, but we're not his alter ego. There was no allegation that we were. We are our own institution with our own other shareholders and creditors. Ms. Hussain owns 20%, the other 20% in trust. He says it may be the offer cannot be made into a court order in the form that it is, and it couldn't, and it wasn't. So he then says the order I make in respect to this disputed area is that the parties must endeavour to agree the terms of the purchase of replacement property for the wife, as set out in paragraph 130 of the judgment. And then if they cannot agree, there's permission to the parties to apply to the court to adjudicate, but only after, in the event of a notice of appeal is filed, the Court of Appeal has determined the outcome of the appeal. And it's those two paragraphs we say that are objectionable and the excess of jurisdiction by the judge. He did not have jurisdiction to order us to negotiate further with the wife, and he did not have jurisdiction to constitute himself, in effect, the arbiter of terms of an agreement in the event we did not reach an agreement with the wife in relation to those terms. Courts do not make contracts with parties. Now, we've set out in my submissions, my lords, paragraphs 17 to 25, if you like, in further detail, why we say the court doesn't have the jurisdiction that it's purporting to exercise in paragraph 10 of the order. I don't propose to take you through all that unless it would be helpful. The point ultimately, I say, is a very simple one. IIB articulated during the trial what it was in principle prepared to agree to do in terms of the rehousing of the wife and her children. It was under no obligation to meet her housing need, but the judge clearly considered what it proposed to suffice to meet her housing need. Whether or not that proposal amounted to an offer to contract with her on its terms, the wife rejected that offer. We then, as we've seen, rejected her counter-offer, and she rejected our counter-offer, and there were and have been no further offers between the parties. At no time did we agree either with the wife or the court to submit ourselves to a process whereby the wife could push for different terms to those in our proposal, or for those to be imposed upon us by the court.
Was the judge saying that he was going to impose on you? Doesn't the note that you taken us to illustrate that the judge thought that he didn't have the recognised that he didn't have the power to order you?
Well, I think this is, if I may say so, and with all respect to Sir Jonathan, who was a delightful tribunal to appear in front of, he's intellectually confused, because on the one hand he recognises that he didn't have jurisdiction, as it were, to impose an order upon us, but then in an attempt, which one understands, if you like, at a human level, to cut through this messy situation, he says, well, what I am going to order you to do is go away and try harder to reach an agreement between yourselves, and if you can't, then you've got liberty to apply to me to come back to do exactly what I've just said I don't have jurisdiction to do.
Now, pausing there, I accept that vis-à-vis the bank. On the basis one of the main issues in front of him is to deal with provision of housing for the wife and child. Was he able to make that order fixing simply the wife and husband? In other words, it's the judicial crystallisation, isn't it, of your I'd like an adjournment, can we have an adjournment? He says no, but I'm going to give the parties time, and if they can't agree, they can come back.
Yes, in this sense, in that if that was then a matter of private grief, as it were, between husband and wife, I accept, and indeed I'd invited him to adjourn on the 15th of December to see if the three parties could reach an agreement, having failed to reach an agreement before that date. He could, of course, then say, I'm going to do that. If that doesn't work, then I need to come back and consider what, as between husband and wife, I should do in the event the bank hasn't agreed to make a proposal to the wife that she has accepted in terms of her and the children's future accommodation.
Well, I'm glad we're agreed about that.
And in effect, that's almost what he did, slightly oddly, in I think it's paragraph 154 of the judgment, where you'll see he says that the lump sum of £6 million, I think it is made up in the following way. And one of the ways it's made up is a 2 or 2.2 million housing fund for the rehousing of the wife. But that at that point, I think in the judge's mind, was coming from my client, not in fact from the husband. He could have turned around and said, well, if the bank's not going to do it, it's just that the husband will have to do it out of the £6 million that I found he's got and ordered him to pay.
Okay, well that then takes me to my second question. And I do appreciate your submissions about jurisdiction and undertakings.
Yes.
Paragraph 11 of the order is obviously his attempt to, well, let me ask you, is that an undertaking that you proffered?
My recollection is we either proffered it or we didn't in any sense resist it when it was either suggested by the wife's team or by the judge. It may have been something the wife's team suggested and we were content with, because we were not seeking to put the wife and the children on the street. At this point, we were seeking to find a way through which all parties could live with, which would provide for the housing.
So in a sense, do you say that paragraph 11 is a freestanding unobjectionable undertaking, or it was a component of your position generally about the property?
It's unless I'm misunderstanding my Lord's question.
Well, it goes to remedy, really, if your appeal has any grounds of success, what in fact the impact on the order would be, which is why I'm exploring.
Well, my appeal is against paragraph 10.
I know.
If paragraph 10 is set aside, then on the terms of paragraph 11, it falls away. Because paragraph 11 only, I'm trying to find the actual order, only sits there.
Page 63.
Page 63, I'm being told from behind, only sits there unless and until this appeal succeeds.
And in that case, therefore, why does not paragraph 12 fall also? Because isn't paragraph 12 the other side of the coin, permitting the bank to deal with the family home as a result of whatever happens under paragraphs 10 and or 11?
I think I agreed with my Lord and my Lady earlier that yes, that also falls away in the event. So that was sitting
Well, I
there.
thought you had agreed it initially, and then when I
Yes.
explored it with you, I think you said it stayed, which is why.
Yes, and then I think my Lady Justice King came back at me, and I think I reread it and thought, yes, I agree. I agree with the ladyship, but it also falls away because that's only contingent, if you like, on. I mean, the reason why that hasn't kicked in yet is because the husband has appealed, and we're waiting to see what the outcome of the husband's appeal is. But if, for instance, the husband's appeal were to fail, then the obligation on the wife to apply for the removal of the restriction kicks in.
Well, yeah, but that submission suggests that you say it survives your appeal.
Yes, sorry, my lord. Yes, I'm confusing myself and you.
You're certainly confusing me.
I'm so sorry, my lord. I'm saying it survives the appeal, and the stay upon it, because this appeal is being heard with the husband's appeal, if you like, the current stay upon it, upon the wife's obligation, will also fall away when these two appeals are being dealt with.
So she would still have a positive obligation to the court to remove the restriction.
Yes, I think that's right.
Because it seems to me that 12 made its way into the, and obviously I wasn't there, I can just track it through the documents and the transcripts. 12 made its way in there as a quid pro quo for freeing up the provisions for the bank to dispose of the family home.
Well, no, I think it was more complicated than that. And I may get this wrong, and Mr. Glazer will correct me if I do, but I think the wife had essentially had applied ex parte for a freezing injunction and for the imposition of the restriction. And we had not sought, if you like, to go back and argue out the correctness or otherwise of the imposition of the injunction and the restriction, because that seemed a waste of costs. But our position was, if the wife's argument that the FAP was a sham failed, then on no basis was she entitled to maintain the injunction and restriction on the title, and therefore it should automatically fall away.
Right.
I understand.
I think that must be right. As I say, given there's a minor child and a disabled child in the home, that doesn't mean, if you like, the possession follows as night day.
Well, that's why I'm asking.
Yeah, but that's just I'm also not a landlord and tenant lawyer, nor I think it's probably anyone in court. But that's whether the bank would want to move to get possession immediately, as it were, is a question for a different day. As I said,
But it might not be though. It might be a question associated with any relief on the success of the bank's appeal. In other words, it might.
Well, I don't think so, my lord. If I'm right that the court had no jurisdiction to grant paragraph 10, then in my submission, the court has this court has no avenue available to it other than setting aside that part of the order.
That might be right, but there might be other parts of the order that go with it, depending on why and how they've made their way into the order, given the circumstances, and as you've pointed out, the minor child and the disabled child.
Well, that may be right, my lord, but Mr. Glazer hasn't
It won't
advertised.
concern you at the moment.
Well, in a sense, if it doesn't concern me and my client, then
It
I'm
concerns
probably
the court
unconcerned.
in the sense of suitable relief if the appeal were to succeed.
Well, I don't know if that's right, my lord. If the court had no jurisdiction to grant paragraph 10, and it falls to be set aside, your lordship may have something in mind that I don't, but I am, I think, unaware of anything else, any other moving part within this order that was, as it were, predicated upon paragraph 10 being something the court could and should, had jurisdiction to and should have exercised the jurisdiction so as to order. I don't think it would...
Paragraph 11.
Well, paragraph 11 I accept, but paragraph 11 on its terms is an undertaking which is only to remain in place until the second respondent has successfully appealed paragraph 10. So that must go, because our undertaking was only given on that basis.
So, yes, okay.
And we can't be held to an undertaking beyond that we gave to the court. Our undertaking was always on the basis of this.
Maybe we're at cross purposes about what you mean by paragraph 11 goes. You don't mean paragraph 11 should be removed from the order, you just mean
Yeah, I just mean it has no effect in law. Our
you
undertaking
can't
is spent.
distinguish.
Yes, our undertaking is spent on this appeal succeeding. Yes.
Now, where have we got to? Mr. Richardson, I don't want to rush you, but maybe that's a convenient moment. How
I'm so
much,
sorry.
is that a convenient moment?
It is indeed. I'm so sorry. I didn't notice the time. Yes,
No,
indeed.
not at all. How much more have you got to go?
I think all I've got left to do is address the various arguments made in Mr. Glazer's skeleton, all of which I say are bad, but I'll take those as quickly as I can tomorrow morning.
So, very well. Yes.
My lady, can I raise a point at this juncture, which relates to my client's appeal?
Yes.
As you and my lords will have gleaned, the appeal that we bring and application for permission to appeal out of time only needs to be considered if an appeal is allowed for either the bank or the husband,
Yep.
and in circumstances where the matter is not remitted for a full trial. So if you were to allow, say, the husband's appeal or the bank's appeal and remit it for a retrial, because of what we say in our appeal, that the question of the judge's assessment of the fact is tied up with the agreement we say that the bank made, then we don't need to consider that appeal. If, on the other hand, your decision was to allow either of the appeals and not remit the whole matter for a retrial, then I would press it. And I only say that because I don't want to be impertinent to the court, but I wouldn't want to take up time tomorrow if the court was to indicate that if either appeal was to succeed, the matter would be remitted, then I don't need to trouble the court. If everything is open, then of course I will press that appeal.
That's really helpful. So your position is that in the event that the court, without giving an indication of outcome in relation to either of the two appeals, does, however, indicate in the event that either of them was allowed, you would have taken the view that there should be remittal, then you wouldn't be pursuing your appeal.
Correct.
Anything else? Thank you all very much indeed. 10:30, please.